Hi, this is Alex Meyer and William Clardy. We're here with the Pro Bono Partnership of Atlanta, and we're going to be talking about the Defend Trade Secrets Act and confidential information. My name's Alex Meyer. I'm an attorney at Seyfarth Shaw. I do labor and employment work and specialize in trade secret and non-compete litigation. And William, do you want to introduce
And
yourself?
my name is William Clougherty, and I work as an in-house attorney with Elevon. We're a subsidiary of US Bank, and I practice in the area of corporate commercial law in the electronic payments industry. And I focus, one of my focus areas is in confidentiality and privacy agreements.
So, to give you a little bit of a disclaimer, as you're going to hear from the conversation and the information that we're going through, uh, what exactly constitutes a trade secret and what is considered confidential information is a very fact-intensive kind of process. And so this is just a general guideline for Georgia nonprofit organizations and is not meant to be legal advice. We encourage you to consult an attorney regarding the specific circumstances regarding the information that you're concerned about or the process for protecting that information. And the views that William and I are discussing are not those of our organizations. William, do you want to
And,
talk about the pro bono partnership?
and to speak about the mission of the Pro Bono Partnership, the mission is to maximize the impact of a pro bono engagement by connecting a network of attorneys with non-profit organizations in need of free business and legal advice, legal services. Um, in order to be a client of the Pro Bono Partnership of Atlanta, an organization has to be a 501c3 or non-profit organization, must be located in or serve the greater Atlanta area, serve low-income or disadvantaged individuals, and really be unable to afford its own legal services. We have a website at www.pbpatl.org, and we host free monthly webinars such as the one you're hearing today on legal topics for non-profits. To view the upcoming webinars or workshops, you can visit the workshops page on the Pro Bono Partnership of Atlanta website. And you can join our mailing list by emailing rla@pbpatl.org.
All right, so let's go ahead and get into the substance here. So, oftentimes you hear people talk about trade secrets and confidential information as if they are distinct, as if they are kind of the same concept. But trade secrets is a legal term of art and refers to a specific kind of non-public information that your organization may or may not have. Confidential information is information that is important to your business. It could be about your business. It could be some of the metrics for how you track your performance. But trade secrets means something in particular. It's information that you would consider to be the crown jewels of your organization, things that you would not want your competitors to know, things that you take active measures to restrict access to. In the nonprofit context, you might think that, well, maybe my organization doesn't have any trade secrets because what you're talking about deals with things that are valuable to competitors. And that's more of a commercial for-profit concept. But nonprofits can and do have trade secrets. For example, one of the objections that the Red Cross made when they were asked to turn over documents relating to how they spent funds related to Hurricane Sandy is that they withheld information on the basis that their operations manual, their methods for gathering funds, and some other internal documents constituted trade secrets. So your organization could have trade secret information. On the next slide. So as some examples for trade secrets, you have kind of the quintessential one would be a recipe or a formula, like the KFC spice recipe. What they do there is they take half the ingredients in one facility, they take half the ingredients in another facility, and then they bring them both to a third facility and then combine them. So those are kind of the examples of something that an organization does in order to protect how they get their in this case literally secret sauce. Another example would be Goldman Sachs. They have proprietary algorithms and source code they've used and have actually prosecuted individuals for misappropriating. That information can be in the form of a database, it can be in the form of a program, or it can be just in the way that the information is organized. All of those things, depending on the circumstances, can be trade secrets. A third example would be a formula. So in the nonprofit context, it could be a formula for determining how to allocate money. In the commercial context, you can think of something like DuPont. They have a specific formula and method for producing Kevlar or for producing titanium dioxide. And both of those formulas have been subject to efforts to steal them. In one case, um, a South Korean company ended up paying approximately $900 million in criminal fines for trying to steal the formula for Kevlar. So to bring it back to what are kind of the overall factors for this, one thing is that it has to have economic value. It can't simply be that this is something that your organization finds important in the abstract. While the economic value can be actual, as in you know that this information will be helpful to your competitors in your space, or it could be potential information that may be helpful to your competitors. Further, there need to be reasonable measures to protect this information. You can't just leave it out in the open. It can't be sitting out on a desk. It can't be on a shared Google Drive. There should be some kind of measures, whether it's through a confidentiality or a non-disclosure agreement, or through password-protected access to that particular information, through training with your employees, or limiting the kinds of devices that employees can use to access this information.
And turning to the other side of the coin is the items of confidential information that would be shared between an organization and another organization. These are items of information that don't quite fall in the standard, reach the standard of being a trade secret insofar as they're not an algorithm and they're not a formula that is being produced by that organization, that is protected by the organization as the way it does its business. Items of confidential information are really items such as customer lists and pricing proposals, information about how you would do your business or how you perform your function as a pro bono organization, that if it got into another party's hands, it would be a benefit to that other party, but it would also be detrimental to you as an organization. Particularly in the area of non-profit organizations, this sort of confidential information could even be lists of clients, for example, the list of organizations that are members of the pro bono partnership would be considered confidential information. It's something that would need to be protected if it's shared with another party. And the reason that we share the confidential information is that it enables both parties, both organizations, to do whatever they're agreeing to do between themselves to perform their own functions. And life just wouldn't happen, business wouldn't take place if we weren't able to share and protect that confidential information. So it's really information that's important to your organization, and it's not generally known to the public, and if it did become known to the public, it would be harmful for you if that took place. It's more about the organization rather than a trade secret as to how the organization works. It's not. You could put together a number of items of confidential information, none of which would be a particular jewel in its own right, but if you put them all together, they would be Alex's crown jewels and maybe a trade secret. Nevertheless, it would just be, as an individual item, it needs to be protected. And Alex, if you're able to discuss the Defend Trade Secrets Act and how that would work.
Absolutely. So one of the big news, one of the big events that's happened is in June 2016, Congress passed and President Obama signed the Defend Trade Secrets Act. This is a pretty major development inside of the trade secret space because trade secrets law is actually a common law tort. So each state has sort of their own definition for what's a trade secret. What constitutes misappropriating a trade secret? So when does somebody steal it? Under what circumstances is a misappropriation wrongful? What defenses do people have to misappropriating a trade secret? And the Defend Trade Secrets Act, as a federal statute, provides a supplemental remedy beyond what each individual state does. That's helpful in the sense that it unifies otherwise disparate areas of law and provides us with kind of a general remedy that we can point to when you're assessing whether there's a potential misappropriation claim under any jurisdiction without looking at state-specific factors. In terms of the nonprofit industry, the Defend Trade Secrets Act only makes a few things that should be on y'all's radar. First of all, that it exists, that there is a federal statute that now governs misappropriation claims, in addition to remedies that may be available to you under state law. It also provides for some additional remedies that are not traditionally available under state law, or if that remedy were available, it was limited to very particular circumstances and had some limitations on it that made it very difficult to obtain. One example of that would be ex parte seizures. That was something that you could obtain previously by requesting something called a temporary restraining order, an ex parte temporary restraining order. Now there is an additional right to actually recover whatever information was misappropriated in certain provisions. It's very hard to meet. It would be very expensive to actually obtain one of these, and there are certain certification requirements that have to be made. So it would take a theft of information, or theft of trade secrets, of fairly colossal importance before it would be cost effective to pursue that kind of a remedy. More immediately, one of the things that the Defend Trade Secrets Act does is it incorporates a whistleblower requirement. So in your non-disclosure agreements, in your confidentiality agreements, you have to indicate that whistleblower protection is available under the DTSA, and that employees will not be penalized for utilizing that whistleblower protection. That protection is available in very limited circumstances, essentially only in compliance and in cooperation with an investigation by some kind of government officials. But if you do not have some kind of whistleblower immunity disclosure inside of the NDAs or your confidentiality agreements, then you are not able to recover attorney's fees if you bring a claim under the DTSA. So that's one of the important things because, for example, just a few days ago in Texas, an employee was found guilty of misappropriating trade secrets with the harm to the organization being $0, but the company ended up recovering approximately $11 million in attorney's fees. So, the difference between them getting 0 and getting 11 million, so at least they were made whole, would have been changed if this statute were active at the time of, if that statute were active at the time that this gentleman misappropriated the trade secrets information. So the general takeaways for the DTSA is it's a very powerful statute. There's a lot of very interesting things that you can do with it, but actually bringing a claim under it and seeing it all the way through can be very expensive. Zillow, for example, spent approximately $42 million just in attorney's fees prosecuting one trade secrets dispute in 2015 and 2016. Now, it was a large case. It dealt with the theft of a lot of confidential and trade secrets information, but it goes to show that not only are these claims somewhat difficult to establish, you have to do a lot of things on the front end in order to make sure that you establish the secrecy that's necessary to bring a trade secrets claim. But also, once you get into litigation, not only are you incurring attorney's fees, these disputes often require substantial, sophisticated work by forensics professionals, such as imaging computers, or going through and determining whether wiping tools have been used to kind of hide the trail for individuals who have taken information. So the claims can get very expensive, and it can require a lot of time from individuals inside the organization to actually see these through. So, as is often the case, a penny of prevention is worth a pound of cure. So, in the immediate future for your organizations, the only thing that's particularly impacted by the DTSA is to update your non-disclosure agreements, update your confidentiality agreements. For employee handbooks, it's also helpful to include if you have a section on intellectual property, to include the notification regarding whistleblower immunity that's required by the DTSA. Next slide, please.
And turning over to identifying confidential information versus identifying trade secrets. information. And at this point, just to remind people who are watching this live, if you have any questions about what Alex is delivering or I'm speaking of, please feel free to email them in, and we'll leave some time at the end of this webinar to answer any of the questions online as they come up. So identifying confidential information as opposed to trade secrets. And it's important to be able to identify confidential information, particularly if you are starting to have a negotiation or a conversation with as a non-profit organization, a supplier that's a commercial enterprise or another non-profit organization or a government entity, as may be the case, because a lot of information will be transferred and shared during the course of meetings, emails, disclosure of documents and the like. So you need to be able to identify what exactly is going to comprise confidential information. And the way that this is often done is by signing a non-disclosure agreement, an NDA as they're frequently called, at the start of the negotiation. And in there, and we'll go through some of the major points, the major, major contents of a non-disclosure agreement. But one of the first things that you have to do is identify what is confidential information and how it's provided. The first one is it's confidential information that is actually a document that says it's confidential information. It's written on the top, confidential, proprietary, parties' eyes only, that sort of thing. That's very straightforward. You know what you have to do with that confidential information because it's identified there, and you have obligations under your non-disclosure agreement as to what you need to do with it. Another type are materials that are presented in writing with either which are not actually marked confidential and proprietary, but you would have received a notice from the disclosing party in advance that what's going to be delivered or what's going to be presented on a slide or whatever is confidential information and should be protected. Or you'll receive notice shortly afterwards, often written notice, to say that what we've provided you during the course of that presentation or what we've given you by way of documents, although they didn't state it at the time, we're telling you now that they're confidential. You need to protect them from here on in. That's a less common. More common are the items that are actually stated and described as confidential information, and also a broader area or a broader almost a catch-all are those items of information that you would share that if you looked at it you would see quite plainly, well, this is confidential information, this should not be shared. If this got into public hands or this got into one of these parties' competitors' hands, that would cause trouble for the party that gave it to you. So it's information that would reasonably be identified as sensitive, confidential, or just not for public consumption. They will be the items of information that will be described in those terms in the non-disclosure agreement. So what are they? Say the top 5 items you need to look for in a standard non-disclosure agreement when you're being approached or you're approaching another party when you intend to share information that you want to protect because it's sensitive. The first thing is the non-disclosure agreement should clearly identify what the purpose of the disclosure is. This is why I'm giving you these documents. The reason for that is because we're talking about me selling you a service or a product, and this is the proposal for the product, and this is confidential information. You're to use this in order to evaluate whether or not you're going to take my product. That would be a brief description of a purpose for the agreement, for the disclosure of confidential information. The next one, importantly, is how long the confidentiality period should apply for. Now, particularly in Georgia, it is difficult to enforce an agreement that has an infinite period of confidentiality. There should be some finite period for general confidential information, not to be mistaken for items that are either trade secrets or items of personal information, which are usually protected by the law of the state or by statute. And they will often be either as long as that item remains confidential or sensitive. Personal information, personally identifiable information, again, is protected for as long as it is. So it could be a finite period, an infinite period. Your pricing proposal, your code for certifying to a system, and computer codes and the like, other documentation, they should have a finite period. It doesn't matter what it is. It has to be fairly reasonable insofar as long as it will actually remain confidential and won't expire or be renewed. But the actual period needs to be stated in the agreement: 1 year, 5 years, 10 years, well, whatever. The agreement itself can go on as long as you want it to remain in place until you terminate the non-disclosure agreement. But the actual period of confidentiality should be a finite period. Conditions for storage. What happens when you receive the confidential information? How are you to protect it? Typically, you're being asked to protect it in the same manner that you would protect your own confidential information of a similar nature. So, if you're receiving confidential information that is on a customer list, you treat that in the way you would treat your own customer list. But the bottom line is, it should be a reasonable protection. It should be reasonable protection of that information, depending on the type of information that is being disclosed. So, if you had a difference between, if you will receive, for example, as an item of trade secret or confidential information, if you were to receive the KFC formula, you want to treat that in the same manner as your own formula if you were also producing that product. And that would be a very high standard. If you were to receive less intrinsic, less sensitive information, your standard would be how you normally treat your emails that come in, how they're protected, password protected on your system, and all that. Another very important point is the non-disclosure agreement itself. Where is that governed? Is that governed? What is the governing law? What law applies to the agreement? And if you have a dispute under the agreement, where are you going to settle it? Where are you going to fight it out? Is it going to be in the courts? Are you going to go into an arbitration? Are you going? The important point is the important point of this is that governing law and venue is important. Different states treat different types of information rather differently to other states. For example, if you have a California IT company who are sharing confidential information with you, California law will treat that company's information perhaps a lot more robustly than another state will. Another example would be if you have information that is used throughout the U.S. Oftentimes you might want to say, well, we apply New York law to this because New York is a very generally standard neutral state. Not a lot of companies and a lot of organizations who aren't residents in Georgia will be happy to subscribe to, as with a lot of Georgia organizations. If you're both in Georgia, Georgia should apply. If you can get it in Georgia and you're the organizations in Georgia, it's probably best if you can try to be in Georgia. Another important point is the information that you provide is just information that the other party can use within the purpose that's stated in the agreement. There's no warranty as to its accuracy. There's no obligations to enter into a substantive agreement at the end of this sharing of information. So what they see is what they get, and what you see is what you get. That's an important point. And those 5 points are points that should be in the agreement, clearly stated. And just as a side note to that, a couple of items that should probably not be in the agreement. There shouldn't be a non-solicitation clause which goes beyond the area of a confidentiality agreement. Sometimes a party will put in a non-solicitation clause so that the parties are obligated, not prohibited from trying to recruit employees of the other party that they will meet in the course of negotiations. That's probably outside the area that a non-disclosure agreement should apply. It should be subject to a separate agreement. Similarly, a non-competition, a non-compete clause. Again, that's something that would be, if there's a broader substantive commercial agreement or business agreement of any kind, that area, a non-competition, similarly to non-solicitation, that should be dealt with there, not in the non-disclosure agreement. Very briefly, 5 pitfalls that one should always look out for when you receive a non-disclosure agreement, when you're looking through it, and it's always a good idea recommend have an attorney look at the agreement to make sure that it fits in with the current standard for non-disclosure agreements. Make sure it covers your materials as well as their materials. Make sure it's a mutual non-disclosure agreement. You need to read the agreement to be able to make sure it does, because that is how the parties will identify who the disclosing party is versus the receiving party. So it's very important. Secondly, it needs to provide for electronically archived information where it's not commercially or feasible to go into your system at the end of the negotiation and retrieve all the information from your backup archives and either return it to the other party or destroy it. That's an important point. It's just not feasible to do that. But if you don't have a provision that excludes your obligation to retrieve and return or destroy it, you may be in breach of the agreement by not doing so. You also may, depending on the organization concerned and the functions of the organization, you may have a need to retain a copy of the information received, depending on the type of negotiation, for regulatory purposes. So you may not be able to return and destroy every copy of the information received. It's important to have that if you're the type of organization that could be a non-profit organization that would have that regulatory obligation. Very importantly, make sure your systems can support your obligations under the agreement. You don't want a clause in your non-disclosure agreement that requires you to apply what's been very helpfully described as the security measures of a Fortune 500 company to a non-profit organization that doesn't have the security and infrastructure of its systems. But if you sign the agreement with that type of language in there, then you may already be in breach of the agreement. So you want to make sure that the systems you have are commensurate with the obligations that you sign up to in the non-disclosure agreement. Another point that's worth noting is when you're talking with a government entity, any arm of state government or federal government, be careful of the Freedom of Information Act, which each state has its own, or many states in fact now have what are called Freedom of Information Acts, colloquially called sunshine laws, and where anything that the government entity receives, with certain exceptions, may be the subject of a Freedom of Information Act application to disclose by any member of the public. So it's very important to be able to know that if you're dealing with a government entity, that there is a potential for a Freedom of Information Act request for whatever you supply to the government entity. Depending on the conversations and negotiations you have with the government entity, you may not have much choice if they're regulating you in some way. But if it's a commercial or a non-regulatory relationship which you're proposing, be careful of the Freedom of Information Act. That may dictate what you're prepared to disclose to the government entity. There are again exceptions that you have to look on a case-by-case, state-by-state basis.
And to just add on to that point, the federal FOIA does have an exception where you are allowed to redact trade secrets and confidential information from material that you have to submit to the government. Part of the reason why is that the government wants you to, give them everything. So, and it's also standard to have an exception inside of non-disclosure confidentiality agreements where a federal entity of some kind is compelling you to provide the information, or you have to provide this information in order to meet your federal or state compliance obligations. So that's also something to dovetail on what William was talking about, that you should make sure that there's an exception under the non-disclosure agreement. And the way that that's usually handled is it is carved out from situations when you can disclose the information, and then usually your ability to provide that information is contingent on you providing notice to the other party. So I guess we'll open it up to questions. Are there any questions?
If you would please repeat the question into the microphone before you answer it,
Okay.
I would appreciate that, because I don't know if that comes from anyone. Can you give some examples of circumstances where a non-disclosure agreement
I can take that one.
Okay.
Certainly. So the question is, could we provide examples of circumstances where a non-profit organization would want to have a non-disclosure agreement in place? Certainly. Well, really, it's any situation where where the organization is going to be discussing a potential project or a potential business relationship. The organization may be purchasing a system or purchasing products where they're likely to share information that is sensitive. So it's very broad-based. Similarly, they don't have to be profit-making projects. They don't have to be lucrative. They can be projects just a joint enterprise of some, in the loosest sense of a cooperation. So really any project that would involve sharing your information or receiving information from another organization, whether it's a commercial organization or a profit organization, that will be sharing information we want to protect, not sensitive information. So it's very broad based. Usually it would be where you're purchasing services, or you're making a pitch to another organization about what you do that would involve going into your membership lists and the like.
Would it be important to have some kind of confidentiality agreement with employees and other people who work for you?
Sure, I'll handle that one. So the question was, would it be important to have confidentiality agreements with employees or other individuals who work for you? It certainly is. The main crux that you have to kind of look at before you start getting into the exact language for an NDA, a confidentiality agreement, or policies that your organization is going to have is what information should be protected. So if you start there, you don't want to over-restrict access to the information that's on your systems. Employees will not be happy if they need to engage, if they need to go through 3 steps of authentication in order to access, basic files like letterhead. There's no reason to have that. So, just kind of, it's better to think about it in the broader sense of which information does my organization have that is valuable to us and that I don't want other people to be able to use, or I want them to only use it in service of helping my organization accomplish its mission. Additionally, depending on your organization, you might want confidentiality agreements to make sure that employees do not take things with them on their way out the door. So there are certain common law obligations. An employee cannot engage in conduct that is detrimental to their current employer while they are still employed by that person. In other words, you can't start competing with your current employer while you're still an employee for them. At the same time, the confidentiality agreements, like a confidentiality agreement or something like that, can first of all show that your organization takes steps to protect the information that's valuable. Second of all, it can provide your employees with knowledge to show, hey, these are the things that are important. I shouldn't just be emailing them to my home computer or hosting them on a shared drive. And third, it provides you with greater protection in that it's much easier to show that you have entered into an agreement with this employee. The employee provided information that you designate as confidential. The end. If you're going under the common law or you're going under a pure tort claim, it's a little bit more complicated, and the definition for what constitutes a trade secret or what should be considered confidential information is a little bit more narrowly tailored because the employee, depending on the state's law, might have to do something that is, a per se wrongful act, for example, is one state standard. Another state standard is that the misappropriation would have to be malicious. And proving those kinds of characterizations to the conduct is a little bit more difficult than if you simply have an agreement. In terms of outside individuals like contractors, again, it depends on what information you're giving them. Do you need to have a confidentiality or non-disclosure agreement with, your office cleaning company? No, they're not getting any information that's really critical to your organization. If you have, if you're bringing on, for example, somebody to review your website or something, and they're going to have access to your information, that would be a good situation where a confidentiality NDA, something that limits their ability to use that information and assigns rights to some of the information that you might later want to find to be your own information. For example, the source code of the website would be something that you would want to take care of on the front end.
Next question is, with the high bar for something to be a trade secret, is it likely that an organization would only have confidential information?
I'll handle that one. So the question is, with the high bar for information that qualifies as a trade secret, is it likely that an organization will have trade secrets or will just have confidential information? And it sort of depends on the kind of business. So a good example, and again, it's going to vary from state to state. To give you an example, Florida, for example, has basically a straight bar on customer lists. A customer list is not a trade secret, pretty much ever, unless it is in conjunction with additional information like order history or things that are particular to that customer that give value beyond simply contacting those customers. On the other hand, other states like Georgia and Michigan actually have language in there that indicates that customer lists do qualify. So what you have to do is, sort of look at, first of all, what state you're operating in. Second, what kind of information your organization has. In the nonprofit context, outside of potentially some fundraising related information related to perhaps donation history, aggregated donation history, related to particular processes that you do to have some kind of value add, where you say, we do, this is kind of this particular thing that we do that makes our organization better than other organizations that operate in the same space. Those are the kind of things that, you can say, okay, well, this could be a trade secret. But yes, generally the bar for establishing a trade secret is fairly difficult, and given the audience that we're presenting to, most of it is focused on commercial application and protecting commercial information. That's not to say, however, that your organization will not have any trade secrets. It depends on how you store your information, whether you've compiled some of that information. For example, to go back to what William said, you can have information that is confidential, but if you then aggregate it or do some things to it to make it more valuable than its constituent components, you can turn confidential information into a trade secret. For example, some kind of proprietary database that incorporates particular elements and can search that information using new, novel, or proprietary methods. So again, that's something that is going to fundamentally come down on a case-by-case basis.
This question is for William. You mentioned personally identifiable information as something that may
Yes.
be particularly protected. Can you talk a little bit about how that's protected in Georgia and what sorts of things might be personally identifiable?
Sorry, so the question is personally identifiable information, how is it protected in Georgia, and what types of information would amount to personally identifiable information? The difference in with personally identifiable information is that it's information where that either on its own or in conjunction with another piece of information would be capable of identifying an individual. And so it's really the bar, if you like, is very low on what is personally identifiable information as a definition, and that's the way Georgia treats it. It's a very low bar, but how it's protected is really in the exceptions than in the actual use itself. So if you're a corporation that has or an organization that's receiving a person's name, for example, if you receive an email from someone, it's going to have that person's name, some other identifiable features on the face of it. That's personally identifiable information, and that information should be protected. However, the exception to that is, well, you can't do anything, do business, unless you can identify people, you can talk to them by name, you can recognize them, you can deal with them by virtue of the type of information you're receiving. So that's fine. You can't share that around at will. However, that's fairly low-level personally identifiable information. However, if you have that person then has their address, social security number, their date of birth, that starts to make it a little bit more important because there are things that not only will identify you, but they will be given they're items of information that are unique to you that not only identify you, but they are an avenue into other parts of your life, social security records, your birth, your background, your history, and that sort of thing. So although we in day-to-day average life, we are more than free to we freely share our personal information on YouTube, on LinkedIn, on Facebook, and everywhere we're happy to share it. We're able to control it to a certain extent, but the difference is that if you misuse that information, and if you don't protect that when you receive it in an environment that you are in the environment in which you receive it, then you could be in trouble. So the difference is it depends on how it's actually received and what purpose it's given to you for. I hope that answers the question.
I think it does, and I think it would be particularly important with regard to
Yes, and the comment there, it would be important to receive client information in order to be able to provide services to members or to organization customers. And that's absolutely correct. You have to be able to receive that information, and that's personally identifiable to be able to provide the service that you do. So if you're a non-profit organization and you're involved in providing services to retired folk, helping them with their government applications and the like, you're going to receive an awful lot of personally identifiable information. Some of that information, the people that gave it to you might be on their Facebook, but just because it's on their Facebook doesn't mean you can share it as well. You've got that for a reason. You have to protect it, and the formulation and the way that information comes to you may be an awful lot more sensitive than if you received it in different parts. So that's a very good clarification.
And to quickly add something on that is what William and I are talking about is primarily related to the way that you want to protect your information with respect to your employees and to other entities that you are doing business with. There are other requirements, like those that can those related to personally identifiable information, or those under HIPAA if your organization deals with a lot of medical information. And those, sure, HIPAA is a statute that deals with medical information, and there are certain requirements based on medical information that you have in order to comply with HIPAA, and you cannot freely distribute that information. So to sort of loop back in, if your organization deals with HIPAA-protected information, like medical records are kind of the quintessential example, then that would be something that you might want to fold into a confidentiality agreement with your employees, or if you're providing that information to other organizations to identify that information. I know that's sometimes in non-disclosure agreements there's kind of a two-step confidentiality where you have confidential information because of its business utility, and then there's also personally identifiable information which might be subject to more strict obligations to secure it, or to have it, have limited access to it, or something like that, to prevent inadvertent disclosure.
And on the point of HIPAA, if you are an organization that deals with protected health, what they call PHI, protected health information, you will oftentimes be asked to sign, in addition to a non-disclosure agreement, that business associate agreement, where basically you are going to subscribe to the obligations, to the HIPAA obligations in respect of that information. That party will ask you to sign the business association agreement is required to subscribe to. So you're basically putting yourselves in the shoes of the health provider. Oftentimes they are, most often they're health providers. You're putting yourselves in the shoes of that organization as though you were directly regulated under HIPAA in respect of that information. So you're not directly regulated by HIPAA, but it is as though you are, because the regulation of the organization that's providing the health services is actually extending out a long arm, if you like, thank you very much for the very interesting questions, and hopefully this will be of help to the live audience and those who come onto YouTube or view this webcast in the future. Thank you very much.
Thank you.